Hey, I'd like to thank people for attending the Committee of Adjustment meeting, and I'd like to remind everyone as we get underway that this meeting is in person and online through Zoom and is being recorded. Everyone online will be muted with the exception of committee members and staff. All comments and questions are to be directed through the chair from committee members, staff, and the public. I'd like to remind committee members you must speak into the microphone so everyone online and in person can hear you. For those attendees that are online, your video picture will not be displayed. You will be muted and you will not be able to unmute yourself during an application that you have not requested to attend unless you raise your hand. At the beginning of each application, I will call the application forward. The owner applicant in attendance may come to the table to your right to speak with the committee. This microphone is live and you must speak into the microphone. If the owner applicant is online, you will be unmuted. Excuse me, committee will ask for comments from the public during each application. Please provide your name and address for the public record. All comments, questions should be directed to the chair and only speak when it is your turn. If you are in person and would like to speak to an application one at a time, you may approach the podium and speak. This microphone will be live. If you're on the video portion of the Zoom meeting and you'd like to speak and your microphone is muted, please click the raise hand button located on the bottom of your screen. Staff will notify me that you wish to speak. If you're attending by telephone and you wish to speak, please dial *9 to raise your hand, which will signal staff that you wish to speak. Once a decision has been made concerning your application, you're welcome to leave the hearing while the committee continues with the next application. Members in attendance today are Catherine Graham, Bruce Craig, Paul Veenster, Todd Robertson, and myself, Jim Keogh. Our staff in attendance are Senior Planner Lindsay Lambert, Planner Kyle Peel, Secretary Treasurer Amanda Werner McKellar. First item on the agenda is the adoption of the agenda. Any committee members have any changes they wish to make?
None for me.
None here.
No.
Nor do I. So need a mover and a seconder. Moved by Catherine, seconded by Paul. That the agenda be adopted as circulated. All in favor?
Yes.
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 I am also carried. Okay, the second item on the agenda is the adoption of the minutes from our September 23rd, 2025 meeting. Do any committee members have any changes or suggestions?
I have none.
None here.
Nope.
None here.
Okay, I don't either. So now we need a mover and a seconder. Okay, moved by Bruce, seconded by Todd. That the minutes of the September 23rd, 2025 hearing of the Committee of Adjustment be adopted as circulated. All in favor?
Yes.
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 I am too. Okay. Declaration of interest. Any members with any declaration, pecuniary or otherwise, on any of the ones before us today?
I have none.
None here.
Nope.
None here.
Nor do I. So there we go. Yep. First application today is D13-2025-037 27 Hill Island Heights. Amanda, you give us your.
Yes, and we have the agent and the owner available. The application is requesting a permission to expand the floor area of the existing legal non-complying single detached dwelling. The existing dwelling is legal non-complying with respect to the minimum 30-meter front yard provision of the Island Residential Special Exception 26 zone. The existing 123.4 square meter single-story dwelling is proposed to be expanded with a 63 square meter addition and a 30 square meter addition. The property is currently developed with a single detached dwelling, attached deck, and 2 accessory structures. An existing 9.92 square meter portion of the dwelling and a 31.2 square meter portion of the existing attached uncovered decking is proposed to be removed to facilitate the dwelling additions and additional attached uncovered decking. The application is also requesting a permission to expand an existing attached deck. The proposed deck is approximately 94.6 square meters and is proposed to be located within the 30-meter front yard provision of the Island Residential Special Exception 26 zone. The proposed development also requires zoning relief in the form of a variance for the minimum 10-meter setback from a private right-of-way for the attached uncovered deck proposed on the north side of the dwelling. The proposed setback is 9.88 meters.
Lindsay, would you give us your report, please?
Thank you, Chair, and through you. So this application for 27 Hill Island Heights is a combined permission and minor variance application. The permission is proposing to expand an existing legal non-complying dwelling. The property is located on Hill Island and is therefore within the island residential zone category and is subject to the minimum 30-meter front yard provision. However, the property is not a waterfront lot. 2 additions are proposed for the dwelling and a proposed attached uncovered deck. There is an existing portion of the dwelling and decking that is proposed to be removed to facilitate the additions to the dwelling. In terms of the variance, there is a request for zoning relief from the minimum 10-meter setback to a private right-of-way for the proposed attached uncovered decking. The proposed setback is 9.8 meters from the edge of the private right-of-way. In staff's review of the application, it has been found to meet the 4 tests of a minor variance under the Planning Act. And with respect to the permission, the application's been found to meet the policy tests under the township's land use planning documents for the expansion of a legal non-complying structure. To date, staff have not received any comments from members of the public with respect to the application. The CRCA has noted no concerns with respect to natural hazards, and it is confirmed that no permit under their regulation is required for this proposed scope of work. As the property is within the MGO influence area for land use development, a permit has been issued for the proposed deck. The building department has noted that if the subject application is approved, the condition and capacity of the septic system will be reviewed at the building permit stage. And therefore, in summary, Township Planning staff recommend approval of the application per the conditions and details captured within the staff report. Thank you.
Thank you. Any other comments received?
We received just comments from the Conservation Authority with no objections, and we've not received any further written public comments.
Thanks, Amanda. Is there anyone in the attendance in the audience that wishes to speak to this application?
No, we have no one in the audience and no one online looking to speak to the application.
Committee members, we'll start with you, Catherine. Any questions or
I have no questions or concerns.
Bruce?
Likewise, I have no questions or concerns. I'm good to go.
Yeah, Paul?
No, it looks good.
Todd?
The question I had was around septic, which was addressed in the report, and so I have nothing else.
Okay. We need a mover and a seconder then. Moved by Catherine, seconded by Bruce. Moved by Catherine, seconded by Bruce, that application D13-2025-037 be approved, subject to conditions as included in the planner's report and the decision of the committee. Catherine?
Yes.
Yes,
Yes.
sir.
Yes.
Yes, and I am also carried. Second on our agenda today is D13-2025-040-191 Clark Drive. Amanda, would you give us your report?
Yes, and we do have the owner available. The application is requesting a permission to expand the size and floor area of the existing legal non-complying dwelling. The existing dwelling is legal non-complying with respect to the minimum 30-meter setback from the high water mark of the St. Lawrence River. The existing 181.1 square meter dwelling with attached garage is proposed to be expanded with a 14.8 square meter addition on the southwest corner, a 10.5 square meter covered entry addition on the north side, new covered decking and uncovered decking on the south-facing elevation. The property is currently developed with a dwelling with an attached garage, attached decking, and a shed.
Thanks, Amanda. Lindsay?
Thank you, Chair, and through you. So this application is for 191 Clark Drive. It's an application for permission to expand the size and floor area of the existing legal non-complying dwelling with a proposed 14.8 square meter addition at the southwest corner of the dwelling, a proposed 10.5 square meter covered entry addition on the north side, and then new covered decking and uncovered decking across the south-facing elevation of the dwelling. In staff's review of the application, it's been found to meet the policy tests under the township's land use planning documents for the expansion of a legal non-complying structure. The proposed expansion does not encroach further into the established water body setback of the property. To date, staff have not received any comments from members of the public with respect to the application. The CRCA has provided comments noting no concerns with the application based on its consideration of natural hazard policies and regulation, and has confirmed that the proposed scope of work on the south side of the dwelling will require a permit under their regulation. The building department has noted no concerns with the application, provided all construction meets the 2024 Ontario Building Code, and therefore, in summary, township planning staff recommend approval of the application per the conditions and details captured within the staff report. Thank you.
Okay, thank you. Amanda, any other public comments or any other comments?
Yes, we just received comments from the Conservation Authority with no objections, and we've not received any further written public comments.
Thanks, Amanda. Is there anyone in attendance with the audience that wishes to speak to the application?
We have no one in the audience and no one online looking to speak to the application.
Thanks, Amanda. Committee members, any questions for
I have no questions.
Bruce?
No, I have no questions or concerns.
None here.
Todd?
No, sir.
Nor do I. So need a mover and a seconder. Moved by Todd, seconded by Paul. Moved by Todd, seconded by Paul, at application D13-2025-040 be approved subject to conditions as included in the planner's report and the decision of the committee. Vote.
Yes.
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 And I'm also carried. Next on the agenda today is D13-2025-041-11-35 Clark Drive. Amanda, could you give us your report on the applicant?
Yes, and we have the owner online as well if you have any questions. The application is requesting a zoning relief from the minimum 30-meter water body setback to facilitate the construction of a new 518 square meter marina store, repair shop, and office building. The proposed water body setback is 14 meters. The property is currently developed with a marina, existing shop, office building, and a washroom building.
Thanks. Lindsay.
Thank you, Chair, and through you. So this final application for the agenda is for 11 to 35 Clark Drive. It's a minor variance application requesting zoning relief from the minimum 30-meter water body setback to facilitate the construction of a 518 square meter marina store, repair shop, and office building. The proposed water body setback is 13.5 meters. And the property is currently developed with a marina, existing shop, office building, and a washroom building. Should the application be approved, the development will be subject to an application to amend the existing site plan control agreement registered against the property. In staff's review of the application, it's been found to be consistent with the applicable land use planning documents that apply to the township and meets the 4 tests of a minor variance per the Planning Act. The existing marina use requires accessory buildings that support the marina to be located in proximity to the shoreline. The applicant has submitted an environmental impact statement in support of the proposed development. The EIS concludes that the proposed building achieves a minimum 30-meter setback from the edge of the provincially significant wetland. The setback, combined with the recommended mitigation measures to enhance the buffer area with native trees and shrubs. Should the application be approved, this recommendation will be implemented through the amending site plan control agreement. With respect to public input, staff have not received any written correspondence to date with respect to the application. And the CRCA has noted that the proposed building achieves the minimum required setback from the natural hazard limit of the property, and that portions of the property do fall under their regulation, and therefore a permit from the CRCA is required for the proposed building. In summary, staff recommend approval of the application per the conditions and details captured within the staff report. Thank you.
Thank you. Amanda, any other public comments?
We received comments from the Conservation Authority with no objections, and we have not received any further written public comments.
Thank you. Is there anyone in attendance in the audience that wishes to speak to this application?
We have no one in the audience and no one online looking to speak to the application.
Committee members, any questions?
I have a question about the setback. To what extent is the marine facility to put in and take out boats a constraint on the location of the building? Seems to be right behind it. Is that one of the reasons why the building is proposed to be where it is?
So the building is proposed because of the launch ramp, because of the gas dock, and as well as the septic that was put in 3 years ago that would be able to facilitate this build.
Okay, thank you. Thank you.
Bruce, any questions?
The only question I'm having is the existing service building to remain, or is it going to be demolished?
The existing building will stay.
Okay, no problem. Thank you. That's all I have.
Paul?
Yeah, no, nothing here.
Todd?
No questions.
No, nor do I. So we need a mover and a seconder. Moved by Catherine, seconded by Todd. That application D13-2025-041 be approved, subject to the conditions as included in the planner's report and the decision of the committee. And we're ready to vote.
Catherine, yes?
Bruce, yes?
Yes.
Yes.
I am also carried. You read the other business or? Okay, next on our agenda is the discussion on small accessory structures within 30 meters of high water. And you were going to do that, or how were we? Yep.
Thank you. So through you, we distributed yesterday a document that we prepared. We had a discussion about this previously. I can't remember the previous meeting, but we did discuss it previously. Kyle Lindsay and I have taken it back and looked at it in the context of a lot of the stuff that we have come across our desks on a regular basis, as well as looking at the emails that you've provided in terms of input into it. I know that where the committee was hoping to go was a recommendation from staff in terms of supporting small unenclosed structures to a certain size within this area. But when we look at our official plan policies, as well as there's a concern from an enforcement perspective when we look at the number of enforcement situations that we deal with on a regular basis, that allowing certain size of structure within the 30-meter setback without the need for permits or in compliance with zoning, we're concerned with creep because we currently deal with a lot of non-compliant structures that are being built without permits. We are continuously seeing sleeping cabins and other accessory structures being built beyond the size that's permitted in the zoning bylaw. For example, right now the building code has been amended to allow structures up to 15 square meters without building permits if they're accessory to a residential unit. And we are constantly seeing people coming in with ones that are just over 15 or 5-6 meters. Like, we're concerned about creep and concerned about natural hazards in terms of the variable shorelines. I know this is along the lines of the discussion we had previously, but from a planning perspective, we're just not in a position to be able to say that we can recommend this and feel confident that it's a good planning solution to allow it as of right. And so that's the position that we're in right now. We've provided the document for you in terms of sort of outlining our concerns. I know that there would likely be some people out there that would probably do it in accordance with whatever provisions we put in. But with the amount of enforcement we've been dealing with over the last few years, from my perspective, I'm more concerned about where this would go if we did allow it at a smaller scale, because I do see the creep occurring. And with the amount of money we've spent on legal proceedings and enforcement matters over the last few years, I I can't make a recommendation and we're on the same page in agreement on this, that we can't say it's good planning to allow it. So that's where we are. It doesn't mean that we have to, like, we can have differences of opinions, but that is our recommendation to the committee at this point in time.
I'm going to open this up. Catherine, any questions?
Yes, oops. Thanks very much for the report. I guess you've been very pressed with many, many things, but to the extent it's possible, if you could give this kind of report to us more than a day ahead,
Yeah.
that would be really helpful. I almost did not have time to read it before the meeting, so, but nonetheless, I did, and it was helpful to give background. I guess my concern, and I'm tending to agree with your recommendation. I guess my concern is around the enforcement piece, because as you've noted, and as probably all members of the committee see, there are all kinds of things happening out there that just seem to happen. And some of them have happened years ago, but remain as egregious issues. And others are happening almost as we speak. So it's not immediately germane to what the committee would recommend around this particular issue, but I think it's a very important ancillary issue that I, for one, would benefit from learning a bit more about what the township's plans are in terms of enforcement, other than on a complaints basis or on a, whoop, we're cruising around and we see this basis. So could you maybe give us a little more information about what the plans are for enforcement going forward?
So we have a recently approved enforcement policy. It was approved by council last year. In terms of enforcement, we have one bylaw enforcement officer, as well as our building officials who can enforce building code. We do respond on a complaint basis, but if there's something that we see that's a life safety issue, we are proactive with respect to that. In terms of receiving complaints, we don't take anonymous complaints, but we also don't disclose a complainant's name when a bylaw enforcement issue is reported. It's difficult. We see a lot of the enforcement issues. So I'm not sure if you're aware, we do have a boat now that was acquired a couple of years ago. And through that, getting out on the different water bodies, we have identified a lot of different compliance issues. Unfortunately, this summer we were down a building official, so we weren't able to get out on the water as much this summer as we have in previous years. But we're finding that that's how we're identifying a lot of these scenarios, because the inspectors are getting to know the areas and they're identifying a lot of this construction, because ultimately it does affect our tax base too when people are building things without permits. So while we are primarily complaint driven, if we see something that's life safety, or depending on what it is, if a building inspector is identifying it when they're out on the river or out on one of the lakes, we will pursue. If it's built without a permit, we are absolutely pursuing it.
Even if it's not a life safety issue?
If it's a build without permit, yes. If it's a lot of times, well, so one of the things that we've seen a lot of is stairs. Stairs are exempt from the zoning bylaw. And this is one of this goes back to some of our concerns. Stairs going down the shoreline to, say, a dock, they're exempt from zoning, but they require a building permit. And so we see a lot of people building these stairs without building permits. And a lot of times they are not safe. We've had a lot of issues in terms of enforcement with stairs going up on properties, particularly with very steep shorelines. And so that is something that we've done a lot of work over the last few years in terms of following up with people around their stairs, because that's a life safety issue and we don't want to see somebody falling down a steep cliff.
Thank you.
Bruce.
Yeah, my initial question, I guess, was it seemed this exemption, if you will, for smaller structures within the shoreline setback, is that a kind of a recent allowance in some areas, or or has it been around for a while?
I think it's a recent allowance because the last time the Conservation Authority regulation was updated, it included that. So the Conservation Authority stopped regulating it. So I think a few of the townships where we found those exemptions put it into their zoning bylaws to be consistent with the Conservation Authority. The difference being their mandate is different than our mandate. So I think that was their reaction to that piece, because we do find some challenges at times when somebody comes in and says, I want to build this. And we say, okay, it needs zoning relief, and the Conservation Authority says, it's outside of our regulation now. But we have different mandates in terms of what we're looking at.
Thank you. It's just that, in some of our decisions, the exemption could have applied to, our decision, or even the need for an application in the first place for a minor variance. So that's why I was concerned. The other concern, in a recent meeting, we had two applications for overhead roof protection for an entranceway, for just an overhang of a roof. And, I felt sorry for the applicants to have to go through that for something so minor. And so I'm thinking, hoping that something like that can be addressed with this lesser setback, if you will. So that would be a major takeaway that I would like to see, some action taken on, because it's just so minor in nature that it's a pity that someone has to go through the expense and delays of a minor variance application to deal with that. So I'll leave it with that for now, and I'll pass it to Paul.
So I was just going to say, I didn't appreciate that was a consideration in terms of like a roof overhang over an existing deck. I would agree that that's something that we could probably take back and look at, because if we've already allowed a structure like a deck to be there, the roof overhang isn't creating any additional issue, and the deck itself has already been permitted to be there. So that in and of itself is something I think that we could certainly take back.
Yeah, like to say, as a planning team, you guys have done a super job facilitating constituents in this township. We've had it where it wasn't so super here, and my worry is going forward, when there's a change of guard, that things can go the other direction pretty quick. And that's where zoning bylaws, if they're a little bit more user-friendly, can help people, on these minor, I was thinking primarily on these small structures that don't even require building permits. And I think the reality is, if you have a small waterfront lot and you need need a place to put storage, you're not going to plop it in front of your cottage, block your view. You're going to throw it out behind, but it's on the larger lots. They're on a bank or whatever, so people don't have to drag the kayak up 100 feet up a hill and that sort of thing, where they can get a little bit closer to the water. That was my thoughts. The other thing is, I have a question on where do all these phosphorus come from on these new builds that is polluting Red Horse and Charleston Lake?
So the phosphorus loading is just a byproduct of development in terms of, I know like the septic systems are required to be set back a certain amount. It's just a product of, and I'm so not an expert in phosphorus. It's an MECP thing, and we would defer to them. But a lot of it's provincial regulations, and it relates to the septic systems. But it's also people dumping dishwater or dumping other things outside, and it, by virtue of rainfall and other things running off into the water body. So all of our policies around the phosphorus loading are consistent with provincial policy. In looking at this, I was actually reviewing the New South Frontenac official plan, which was just approved by their council in April. And they have some much more stringent policies in their OP now as it relates to the lake trout lakes than what we have. So in speaking with the MECP, or is it MNR? Sorry, I can't remember which one it was that we dealt with, but we've done 2 zoning bylaw amendments in the last year or so to reduce setbacks to allow people to build on existing lots on, I can't remember if they were Charleston or Red Horse. I think it was Charleston. And the ministry was willing to work with us to try to make sure that these individuals could build on the lot, but there was additional study that was required. So we haven't found them to be a significant obstacle, and they recognize that there is a right to development on an existing lot of record, but we would defer to their expertise when it comes to somebody needing relief for building on one of those lots along Charleston Lake or Red Horse Lake.
Yeah, no, my thought is, I don't know what the setback is. I heard it's enormous on Red Horse.
If it's an existing, so if somebody's trying to create a new lot, you can't create a new lot within 300 meters of the lake on Charleston or Red Horse. If it's an existing lot of record that's developed, you're subject to current zoning requirements. But what we have is a lot of existing lots of record that are just historic properties that are either undersized or they may be standard. But to create a new lot, anything has to be 300 meters from the lake. Even the septic system has to be 300 meters from the lake. So basically what we have around Red Horse and Charleston is what we're going to get. You're not going to see, they're saying they're at capacity, and that's what the provincial policies are saying, and our OP policy mirrors that. So existing development can be maintained. There could be applications to the committee to enlarge or modify structures, but it has to be done through an application, or it has to meet the letter of the zoning bylaw in terms of the requirements.
Okay, I think that's all the questions I have at this point. Thank you.
Todd?
Thank you, and through you, Chair. I'll echo the voluminous nature of the report and the detail where contained within. Thank you. So a couple of questions, or I'll start with observations, actually. There's a comment made on the first page about would not significantly reduce the number of applications processed by staff or heard by the Committee of Adjustment. Clarification, at least from my point of view, and based on the discussion around this table, not really concerned as much about the impact on the committee and the staff as we are about the impact on the ratepayers. So just want to make that clear. I didn't see that anywhere else in the document. So the genesis of bringing this issue forward is the impact on the ratepayers and not the impact really on anyone else. Also, just an observation from my perspective that you're talking about non-compliance and slippery slope and creeping. I can't remember the exact word you used. I'm sorry. It's my respectful opinion that policy shouldn't be dictated by potential non-compliance or by enforceability, but should be dictated by kind of an evidence-based approach as to compliance with existing legislation as well as risk and potential liability for the municipality. So just an observation. And the other observation I think I had, and we had discussed before at this committee, was instead of I didn't think we were fully suggesting allowing kind of carte blanche within the 30 meters, but looking at a reduction for certain types of structures. And I think as we read some of the other jurisdictions, or my reading of it anyways, was that was kind of the route they had gone for, and they were pretty specific about the types of structures that could go. So for instance, from 30 to 10 for, as Paul spoke to, a little storage shed that doesn't need a building permit, perhaps a 10-meter, limit or something of that nature would make more sense. And I just had a question just around the discussion around enforcement. just more out of curiosity, but are you finding enforcement arises more where private homeowners and property owners take their own initiative versus contractors who are perhaps more well-versed with the process? Or I just, in my head, I'm thinking I can't think of a contractor out there that would go and usurp the process and just throw something up for somebody. The liability and the risk there would be so huge. So really, we're just talking about property owners taking their own initiative and
Private property owners taking their own initiative, but there are, there's not one, obviously I can't single out
no,
anybody.
and I'm not
I
asking,
don't-
I'm not asking you
They
to.
wouldn't say that. I mean, there are good contractors and there are other contractors out there that have different practices. And I would say that we're dealing with a mix of contractors as well as private property owners taking their own initiative.
Interesting. Thank you very much. Yeah, I don't think I have any other questions other than, I think you've made your department's position quite clear. And then I guess process-wise, it's just up to us as a committee to decide how we're going to plan to proceed.
If I can just add, you did say something, and Paul mentioned it as well in his comments around like a small shed to put canoes or kayaks or something like that. And I think the other thing that we have a definition for marine facility in our zoning bylaw, which is, it's not the best definition. And I think that there might be some way that we could potentially look and work within that in terms of looking at some modifications to allow something of that nature where it's strictly a small building to contain boats or something, boats, life jackets for storage at the waterfront to support the marine function of the waterfront. One of the examples that we have in this package we sent to you was one that was on Charleston Lake where somebody built up their whole waterfront. And that obviously is an example of what not to do along the waterfront, but some of those buildings were used for a similar purpose to that. So I don't disagree with most of the statements that you're all making. And I would absolutely agree with the statement that policy shouldn't be dictated by the need for enforcement or the ability to enforce it, but policy still has to be clear and enforceable. And part of what we're saying here is based on risk and based on the need for us as planners to be able to make a good, clear recommendation. But I do think that there's possibly some room for improvement based on some of the clarification that I've heard today in terms of your positions and comments as it relates to such as the overhang structures over an existing structure. And I think that we could potentially look at clarifying our definition of marine facility and scoping that to allow something limited along the shoreline. The other zoning bylaws that you're referring to, we're allowing small unenclosed structures and hot tubs and those types of things. Those still cause us a little bit of concern to allow those as of right, but I think that the other element, like what I've identified in terms of the overhangs and the encroachment over an existing structure, I will say that if the committee wants to direct us to look at something around that and look at our definition of marine facility in terms of those small types of structures, that's something we could look at. It's the new structures that cause me concern.
If I may, to that point, sorry, I apologize. Just from a process perspective, I'm just seeking clarification. I don't believe this committee can provide direction. We would have to make a recommendation and direction would have to come elsewhere.
So procedurally, the way, if the committee wanted to request staff to look at something along those lines, would be to pass a resolution asking that council give staff direction to take this back and look at it, and then a report would go forward to council.
Thank you.
So that's an excellent segue to what I was going to ask in terms of the process. So from where I sit listening to the discussion, which is very constructive, I think, it would behoove us possibly to pass a resolution specifically requesting that council ask staff to look at the provisions related to dock structures to support marine activities, overhangs, and possibly items like hot tubs. Okay. And then have that as the next round of discussion. Would that be reasonable?
Just so I understand what you said.
Yeah.
Are you suggesting then that the committee draft a resolution amongst yourself, or even with staff's assistance and then discuss that at the next meeting? Or are you suggesting crafting something right now and passing that today?
No, I'm suggesting talking about it at the next meeting after staff have had a chance to reflect on what the committee has said. And, we'll have another go round. Having, spent a few months sort of waiting for this go round, another month is not going to make a big difference. And this would make it more precise in terms of what the committee feels is most appropriate to recommend to council.
I think based on staff perspective, we could take that back and have something for the next meeting for the committee's consideration.
Thank you. Everybody has pretty well covered anything I had. The only question I had was related to that phosphorus. I don't do dishes, but I think for all the people that do, they've taken most of the phosphorus out of a lot of the soaps used in that years ago. And as a lifetime farmer, I can't see all of northeastern North America is low in phosphorus. I don't know where any lake would get a loading from. It's the most expensive element that we put on crops. So nobody wastes it. I question why would even be a deal. There must be a reason. They must have tested water, but it does not make sense to me.
As I said, we are not experts in that area.
Oh, I'm not.
The ministry has very strict policies around it and around the cold water lakes. So I know that through our conversations with them, they're very strict in terms of those regulations, and that's about the extent of my knowledge on it.
Okay, no, I'm just commenting. It's a low soil element, so I don't know where it would get into the water. Okay, anybody else? Yes.
Yeah, just to clarify, my understanding, as someone who's got a long time interest in Charleston Lake particularly, is that historically a lot of the phosphorus flowed into the lake from the Leaders Creek area, which is sort of the eastern extremity of the lake, which is very marshy, but that's historical and yeah, it has been a thing.
Yes.
Just for the committee's information, council passed a resolution, I believe at the last meeting they had, based on, I think Councillor Kelman brought it forward, and I know that the Charleston Lake Association was a large input into it, directing staff to go back and look at reinstituting a septic inspection program for the township, or to bring a report forward to council in terms of what resources and best practices for other places in doing that. I know that a lot of the concern comes around some of the older developed properties that are around these lakes and these shorelines because of the natures of some of the septic systems and them maybe leaching into the water bodies. So I believe that that's part of the concern.
But we'd have records going back a lot of years. Any development, I'm going to say in the last, 30 years, there would be records with, used to be, I'm trying to think of his name, used to do all the septic inspections, Mark Green or whatever, like.
We have the health unit records. They're
for a long time, yeah.
We do, but they're a challenge to interpret in terms of the way that they've been saved and fined. And a lot of the properties have gone from generation to generation, and there haven't been necessarily improvements to them. So anytime
pretty basic.
Yeah, anytime a building permit comes in for a property, it's reviewed from a septic perspective, but there are a lot of properties where there haven't been building permits or inspections and maintenance inspections over the years. So that's part of the concern in terms of asking for the septic reinspection.
Okay, yeah. Alrighty, thank you. Bruce?
And I agree with Catherine's comments, and I'm just wondering if we might add gazebos to the list, because right now, how do we stand with gazebos within the setback I believe they're concerned, if that's not, is that the case? Yeah, because I'm just wondering that possible exemption of those, so just food for thought.
Yeah, no, I like gazebos as well. And if you do them under the 15 square meters, then there's no permit required. As well, the hot tubs, I think marine facilities, hot tubs, saunas, they all sort of go hand in hand. It's a nice combination. That you want to sit in your sauna, jump in the water, go in the hot tub.
We're kind of coming back full circle to the concerns that staff have around those, is that we don't want those structures necessarily close to the water. People tend to drain their hot tubs, the chemicals can run into the water quality is a concern, and the location of them in proximity to the water is a concern. So a gazebo does require a building permit. It's not an accessory structure. If it's under 10 square meters, it would not require a permit. But if it's over 10 square meters, it would require a permit. The exemption under the building code is for storage buildings that are accessory to a residential dwelling. So anything, and that's 15 square meters. So the gazebo would require a building permit. And then it's cumulative because you get a gazebo with a hot tub underneath it, and then somebody wants a storage building. And so that's where our concern is with the exemption, is that it just keeps going. So we can take that under consideration and bring more information back to the committee around that. As I said, I think that we can look at our definition for marine facilities in terms of a structure for somebody looking to house boats, kayaks, and those types of things. And we can look at overhangs, but I think our position in terms of the unenclosed decks and the gazebos and those types of structures, we do have a concern with it. If there is an area on the property that can accommodate that in compliance with the zoning bylaw, it should be set back in accordance with the zoning bylaw. But again, we can bring back further information to the next committee meeting with some more specifics around those.
So excuse me. So I could just jump in here just to speak to your piece about the phosphorus, Jim. So you are correct that phosphorus is, largely found in soil, right? And the concern is that when site alteration related to development occurs, the phosphorus from that soil is then released in the form of runoff that can head into the water. So in that sense, there's sort of a twofold, right? You have the site alteration will release phosphorus, and then the site alteration will also remove natural vegetation that would block phosphorus runoff from higher up on the lot. So site alteration has sort of a double effect in terms of allowing further phosphorus into the lake, right? Because you have that effect of the phosphorus coming out of the soil from site alteration, and then phosphorus more easily running down the slope through what previously would have been natural vegetation and now is just plain soil, gets right into the lake, right?
Okay, other than it is very stable in the soil, unlike nitrogen, right? Couldn't see where it was a big issue. Like it really is. That's the one thing. And if you go to buy it, 0.46.0, that's buying straight phosphate, most expensive fertilizer you can buy. So nobody is, or unless they're crazy, is wasting it, right? Nitrogen is a whole other issue. I would think that would be a lot worse on water quality for people or fish or anything. And it's overused quite a bit because it is reasonably cheap. But anyway, it was just an observation, like it is very stable, and all of northeastern North America is low in phosphorus, the soils. So anyway.
No, I don't disagree with you at all. It was just, clarification, and especially in the sense that, like it was explained, Charleston and Red Horse are more sensitive to the phosphorus runoff, right? Because of the lake trout lake habitat. So they require that cold water. The phosphorus then can have an impact on that water quality. So while it may not be as big of a concern on St. Lawrence, when it comes to Charleston, the site alteration can allow, phosphorus to run off.
Okay. All in, all done. Next, site plan control. on the
Yes.
agenda is
Site plan
discussion on
control.
site plan control.
Yeah, so Bruce, you brought this up, so if you want to take the lead.
I was rather concerned to see site plan control agreements used in the way that they have recently begun to be used. I don't believe that site plan control agreements were or are intended to penalize residents whose property is on a private road, with the fear that a resident might hold the township liable in the case of a fire, and that they would state that the road wasn't in a good enough shape for fire vehicles to transit. And I just hate to see the site plan control agreement used that way, especially with the costs and legal ramifications incurred. So I'll leave it at that and see what the rest of the members of the committee feel.
Paul, do you want to go next?
Yeah, I personally hate site plan control agreements. I've got jerked around on many of them over the years, many unnecessarily. When you get different agencies, the Cataraqui involved in this and that, and so on. And they're expensive and it affects your title. And for a single family home, I don't see the necessity personally. Multi-residential, I guess, and commercial, industrial. Yeah, but anyways, that's my thoughts. And I know that you have been accommodating, but like I said, if there's a new guard, then they can put somebody's life through hell with these site plan control agreements coming back after the fact and saying you took that hedge down if it was shown on the plan, or you touched this or whatever. And it just to me it's just something that I feel is unnecessary.
Todd?
Yeah, I don't have enough knowledge to effectively comment on site plan control, so I'm just gonna sit and listen and learn.
Catherine?
I'll defer to.
Okay.
Thanks. So we have an official plan policy that says specifically with respect to properties on private roads that the official plan policy indicates that development is allowed and that permissions, any planning approval for a property that's on a private road shall be reviewed in accordance with these policies. And one of them is that if it's located on a private road, that it shall be subject to an agreement to be registered on title, acknowledging that the property is located on a private road and that the township shall not be held liable if police, fire, ambulance cannot get to a property on that private road. So essentially what it is, it's indemnity. In terms of site plan control, I acknowledge what you're saying in terms of involving the conservation authority and that type of thing, but that's not what we're looking at in these site plan control agreements. These site plan control agreements that we're using for this are basically just saying that we're not circulating them to the conservation authority and other things. We're not looking at the development we are putting in the schedule with whatever the committee would have approved in terms of an enlargement or a deck or something like that, to say that development shall be in accordance with the approved minor variance. But the main purpose of those agreements is specifically that. The other tools available under the Planning Act, if we were going to look at it, would be a development agreement, which is the same price as a site plan control agreement and is also registered on title. Alternatively, other municipalities require properties on private lanes to be rezoned to a limited service residential zone, which contains the same provisions in the zoning that say that it's located on a private road. So there's different ways to approach it. I will say that the way we're doing it is consistent with the way many other municipalities do it. And it's specifically because we're implementing our official plan policy to address the liability. And in doing that, we're also making sure that the fire department's inspecting the lanes, making sure that if we're allowing a property to be expanded and improved upon, and someone is investing money in improving their property, that the emergency services, well, it may not be up to standard. We want to make sure that we can get to these people. So it's covering the liability for the municipality as well as looking at the improvement and suitability of it for the property owner as well.
I guess getting back to emergency vehicles and so on, these applications, does it get circulated to the emergency services? And I don't think I've ever seen comments coming back, but I know some of the roads have been a little bit sketchy. Yeah, even for a small car, but anyways, I would think that would be the time to possibly deal with some of these, like I know in other municipalities, sometimes you have to meet the requirement for emergency vehicles if you want to get permission to do whatever. And I guess it's, you're just getting people to sign off so that they can keep their narrow lane. And if their house burns down, the insurance company can't come after the township when the fire department can't get down there. Is that correct? Okay.
Bruce.
You mentioned that the site plan control agreement is a recommendation from the official policy statement. It's a recommendation, though.
Clarification, it's an official plan policy. It's not a recommendation. The policy says that any development of a property subject to planning approval on a private lane shall be subject to an agreement to be registered on title to acknowledge that the property is located on a private lane. There's another, we can provide, when we come back at the next meeting, I think we can give you the policy framework. We could even email it out to you for that matter. It's quite clear in terms of what we need to look at. For that matter, like as part of pre-consultation, before we even look at an application, we circulate the fire department to have them look at the lane. Because if a lane is substandard and a fire truck couldn't even get down there, that's a concern. Or if an ambulance couldn't get down there, that's a concern. So these are things we flag before we even go down the road of someone submitting an application to look at that. So we can certainly bring back more information on that and provide you with the specific policies, but it's not a recommendation, it's a requirement of the official plan.
Okay, sorry, because I thought it was a recommendation. Anyhow, I'm going to go back to Paul's statement about, some way that we could get around this. And I'm wondering, is it just a condition of approval that, that we are not in any way responsible, for the safety of their home, or, because the road, and just make it a condition of approval.
A condition wouldn't address the liability issue because they're not signing off on it. It's not legal and it's not an agreement that's registered on title. So it wouldn't be consistent with the official plan policy. I mean, we could call it a different name and call it a development agreement, but the official plan requires an agreement registered on title because then you've got an agreement between the two parties acknowledging the fact.
Okay, thank you. I just wish there was a better way to address it.
Yeah, one more question. If the fire department takes a look at the road and they say it's a beautiful road, that means you don't have to, it won't get registered on title. Is that correct?
It doesn't mean that, unfortunately, because it's a private road. The township's not maintaining it. It's not being kept up to a municipal standard. So while the road may be in great condition on September 2nd, when the fire department goes down, it's subject to private maintenance and care by a number of landowners. And there could be a washout on the road at some point in time that isn't addressed or something. And so the township doesn't have care and control over that road. So we still want that agreement in place.
Yes.
Well, so just a living example, there was a case a number of years ago where there was a quite substantial four-season home demolished by fire on Charleston Lake, part of a communal lane, and the fire department could not reach it because the lane had been inadequately plowed. So it can happen. Yeah.
Okay, I take a different tack. This was on site plan control. I wasn't even thinking of it on the roads. As far as them, you can't save us from ourselves. I mean, people have to take a little bit of, how would I, take care of their own property, make sure it's plowed. If it's not, I don't think any logical person could blame anything else. But I do have a real issue with site plan control on personal residences. Like it came out there and I thought it was kind of settled a few years ago that it was only going to be on, was it 10 or more units? And it kind of slowed down there for a little while. And then I see our council voted, when I read this, could be put on any property, agricultural, whatnot. That really concerned me. So would you?
Just for clarification, so the province changed the legislation around site plan control and a few years ago.
Yep.
Said that we could only, it used to be 3 units and up that we could apply it, but they said it would no longer apply to anything under 10 units.
Yes.
Then the province came back and changed it and said if it's a waterfront property, we can apply site plan control. With respect to agricultural properties, the only time site plan control would apply to an agricultural property is if there's an on-farm diversified use or a commercial use on a farm. So normal agricultural practices, site plan control would not apply to that. The council has not changed our bylaw. Our bylaw has not been modified with respect to agricultural uses. So grain silos, on-farm diversified uses, those types of things. If someone has like a bed and breakfast or a farm kitchen or something where they're teaching cooking or something like that or a winery, something like that, site plan control would apply. But for a normal farm practice, a new barn going up, it would not apply to that. A new manure storage facility, the site plan control would not apply to that. So if we weren't using site plan control, like I said, we could use a development agreement, which is same thing, different name under the Planning Act, which is a tool that we can apply to any type of a minor variance approval or a committee of adjustment approval. Like I said, when we're using site plan control approval right now, we're using site plan control approval because it's registered on title, so it meets the requirements of the official plan, and site plan control runs on title and is binding on future owners. The same way a development agreement would be. So it's really splitting hairs whether we call it one or the other. The content of the agreement, we're not looking at the house, the setbacks, land. We can't look at landscaping anymore. Actually, we're not allowed to. The provincial government took that one away. So it's limited, like I said, when we're using it strictly to implement the official plan policy with respect to the owner acknowledging that the property is located on a private lane and that should there be an emergency situation, they're acknowledging that it's a privately maintained road that's not in the interest of the municipality and that if police, fire, and ambulance can't get to them, they're not coming back on the township. So that's really what we're using it for. And like I said, we will bring back more information so you can actually review the policy set yourselves at the next meeting.
Okay, so the way the provincial government worded it said that you can put site plan or may put, it didn't say you have to though. So what my question was, it looked like our township council went as far as they could go in applying it on everything, on anything to do with water. Absolutely.
No, so the way the site plan control bylaw reads is that we can use it. So we passed a site plan control bylaw in accordance with the official plan that said that any waterfront property would be subject to site plan control, but we came back and modified it and specifically said that we would only use it when there's conditions that need to be implemented, so that if somebody comes in and gets a minor variance on a public road on a waterfront property, they don't have to go through site plan control. It's only where we need to implement conditions.
So it sounds like you're trying to use a little more
We have discretion.
discretion or common sense than was used right here in the past. Like Paul has said, you guys are pretty good to work with. It wasn't always that way. I can tell you that, so I just wouldn't want it to ever go back to that.
We
that it
don't
was
want to
all
put people through approvals for the sake of going through approvals.
or power and control,
Yeah.
right? Okay, well, I'm fine with that. Bruce.
Marnie, just a quick question. When someone comes in and needs an application for committee of adjustment, and they're on a private road, are they told that upfront before they even pay for the application fee that they're going to have a site plan control agreement and what it entails and what it may cost them? And are they, because I'm just thinking that maybe they're coming in for something very, very minor. And if they knew what a site plan control agreement entailed, they might just say, no, not worth it.
It's part of our pre-consultation process that we tell everybody up front exactly what approvals they're going to be required to go through and what the costs associated with that will be.
Thank you.
The only other thing I will add, I'm just throwing this because it would affect me or could affect me. We built 1,000 feet off the road. My laneway is wide enough to get any legal vehicle and a lot more in and out, right? And I plow it. If we had a blizzard, right? And there's 2.5 feet, 3 feet of snow in my private driveway, until I get tractor and snowblower out and blow it, that's my job, not the township's to worry about. But they couldn't get in there with a fire truck or anything else till I blow it out. And maybe if your house is on fire, you're just not going to get in a real rush to get to the barn, start a tractor and blow the road out. You know what I mean? It can happen. There has to be a bit of reasoning in this, even on that private road deal. Like ours isn't a private road, it's just our laneway, right? But I mean, you could see how it could happen. Right?
I think the difference there is that on a private road, there's multiple properties
Yes.
and different liabilities.
Yeah.
So
Okay. No. But off of that, I mean, I've seen times, you could get in and out with a 4-wheel drive tractor, but you sure as hell aren't going to get in and out with a fire truck. Yeah. Okay. Any other questions, guys? Anything else you guys want to chew at us about? No. So do we need a motion to adjourn? Something else, my dear.
Nope, that's it. I can let you know there will be a couple of applications coming forward for November.
Moved by Catherine. Seconded by Paul. That the Committee of Adjustment will adjourn to meet again at the call of the Secretary Treasurer. All in favor?
Yes.
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 And I am also carried.
Perfect.
What else was it?
Thank you, everyone.